Good morning. Welcome. We're just going to give it a minute, let more people join, but thank you for coming. We'll get started shortly. If you'd like, feel free to put in the chat where you're coming from today, maybe what state you're coming from. We'll launch a more formal poll in a little bit, but feel free to share that in the chat. Hi, Susan. Oh, Red Rock Farm. Good to see you. All right, I might go ahead and get us started. Welcome everybody who's still trickling in. Thank you for joining the Legal Food Hub for our webinar on fiscal sponsorships. My name is Mary Egan and I work for the Legal Food Hub. We are fortunate to be joined today by two attorneys, Elizabeth Manchester and Russell Stein from the law firm Partridge, Snow and Hahn. You go to slide 2, Liz. Before we begin, a little Zoom housekeeping. This webinar is being recorded. Only the slideshow and active speakers will be visible on the recording. We have a captioner with us today. To turn on captions, you can click the CC button in your Zoom controls. If you click the little arrow next to that icon, you'll also find a menu where you can view the full session transcript and adjust additional settings. If you can't figure out how to turn captions on, or would rather see them in a separate window instead of overlaid on Zoom, send a message in the chat and we will send you a link to open the captions in your web browser. To support our captioner, if at any point you are speaking, please start by saying your name and speak slowly. Next slide. All attendees are muted today. If you have a question, please type it into the Q&A and we will try to answer as many questions as we can. You can do that by clicking the Q&A icon in your Zoom toolbar. You can also use the chat box. If you need any help with Zoom during this webinar, just send a message in the chat and our tech support staff member will assist you. Next slide, please. Before I pass it off to Liz and Russell, I want to share a bit of info about the Legal Food Hub. We are a nonprofit that works to connect farmers, food businesses, and food and farm nonprofits in New England to attorneys for free legal assistance. Liz and Russell are two of our great attorneys. You can visit our website, legalfoodhub.org, to learn more about our eligibility guidelines and apply for our services. You can also follow us on Instagram. On our website, we have a resource library with free written legal guides and recorded webinars covering various legal topics. These resources are meant to provide you with high-level information before meeting with an attorney and digging into the specifics of your legal issue. Next slide, please. To help our presenter get an idea of who's in the room, we would like to launch a brief poll. Scott, if you don't mind. And if everybody could take a moment to answer the couple questions on the screen, it'd be great. Great, thank you for jumping on the poll, everybody. Give it another minute. Almost have 100% participation. We'll call it. We can end it there. Thank you. So here's a brief look at who's in the room. So we mostly have nonprofits, a couple of attorneys, welcome. And then most people have been working in the industry 11 plus years, but we have some good beginners, 1 to 3 years. That's great. And it looks like we've got a few people that are searching for a fiscal sponsor and a few people who are existing fiscal sponsors. That's great. Thank you for that. I'm going to stop sharing that for now. All right. So now I would like to introduce our 2 speakers. Attorney Russell Stein of Partridge, Snow and Hahn advises nonprofit organizations, charities, and private foundations on a variety of issues, ranging from startup organizational matters through mergers and dissolutions. Russell provides guidance on joint ventures and partnerships between nonprofits and for-profit entities, including advice regarding state regulations and registration requirements involving commercial co-venture agreements. And attorney Elizabeth Manchester of Partridge, Snow and Hahn advises public charities, private foundations, and supporting organizations regarding board education and training, fiduciary obligation advice, compliance, donor representation, endowment fund management, finance, Form 990, reporting issues, and litigation prevention, and more. In addition, she advises nonprofits regarding managing bequests and complex gifts for organizations, mergers and acquisitions, obtaining and maintaining tax exemptions, policies, political and lobbying restrictions, and tax-exempt organizations. So thank you so much, Liz and Russell. I will pass the mic over to you.
Thanks, Mary. And thank you, Legal Food Hub, for giving us this opportunity to present the topic to you. The issues of fiscal sponsorships are often misunderstood, and a lot of organizations, charities, and non-charities could get themselves into trouble if they don't do it correctly. So we're hoping to give a high-level overview of the rules, give you some tips, and let you go away with some basic understandings of how to do a fiscal sponsorship without getting yourself or the charity into trouble. To start off, we're just going to give a brief overview of nonprofit basics, because these rules are sort of intricate to the understanding of the relationship between a fiscal sponsor and the fiscal sponsoree. So the organization that is not yet a charity still needs to understand these rules so they don't trip up any issues. So first, what is a nonprofit organization? Many people call nonprofits by different names: nonprofit, charities, tax exempt. Depending on the use of the term, it can have different meanings. When we're talking about nonprofits in this lecture, more or less, we're going to be talking about charities. And a charity is something that is an organization that is organized under state law and generally applies to the IRS for tax exemption. It would be under generally 501c3. Those are what is considered charities and can accept tax deductible donations. The IRS does have 29 plus categories of tax exemptions. The C3 category is one of the only ones where people can actually make tax deductible donations to the organization. There's 2 types of 501c3s, what we call a per se charity. Think of hospitals, schools, entities that by their nature are defined as a charity under C3. And then the rest of the organizations can sort of test into the C3 status. And one of the basic tests is what we call the 1/3 support test, meaning the organization has a charitable purpose, which Liz will discuss on the next slide, but also is getting support. At least 1/3 of its support is coming from a broad range of sources that allows organizations with a charitable purpose that are not hospitals and schools to become a 501c3 organizations. The other type of 501c3 is a private foundation, which is also a tax exempt organization, allows tax deductible contributions, but is subject to other rules. We're not really going to go into private foundations on this slide. For entities that are not charities that are looking for fiscal sponsorship, one thing to realize is without recognition from the IRS as a tax exempt organization, any income these organizations receive are generally going to be classified as taxable income. So these organizations that don't have C3 status or any other tax exempt status may be required, and generally are required, to file tax returns and report as income the monies they receive, even if the monies are grants, donations. Without the C3 status or without a tax exempt status, you may need to pay income taxes on those amounts. And that comes into play when we talk about various different types of fiscal sponsorships. If the money actually goes to a nonprofit, to an organization that is not tax exempt, even though the money's coming from a tax exempt organization, the organization that receives the money may have to pay taxes on. There are other types of organizations that you may come across when dealing with farm matters. One that we wrote on the chart is a 501c3, which is 501c4, which is a social welfare type organization. There's also an organization classification called 501c6, which is a business league. What we see is a lot of farmers markets. It might be possible for them to get tax exemption under 501c6 as a business league, meaning a group of farmers who are coming together to present their products to the public. That's not a charity, so you can't get tax deductible donations, but a lot of farmers markets in the area try to get tax exemption under 501c6. There's also a classification called 501c5, which is for agricultural and horticultural organizations. And the key issues under that classification is that you're doing something to develop more efficiencies, neither agricultural or horticultural, improve products, better conditions, something that tries to make that, you're doing something to make that industry a little better. So you're working towards the public good, which is why the IRS allows you to have a 501c5 application. Liz, do you want to take the next, or are there any questions first on that slide, Mary?
We have a couple questions, but I think they can be held till later.
Okay.
Okay. So as Russell mentioned, I'm going to go over now the primary purpose test, which is really for purposes of keeping in mind the sponsor's obligations in taking on projects to fulfill its charitable purpose. And as Russell mentioned, the project should keep it in mind when approaching a potential sponsor, a 501c3 sponsor, to make sure they're not violating their organizational and operational tests. So what are these tests and where do they come from? Under the Internal Revenue Code, under Section 501c3 is a statute that describes what are acceptable exempt purposes. And broadly and generally, those purposes can be religious, charitable, scientific, testing for public safety, literary, educational, or prevention of cruelty to children and animals. They're some of the topics that are discussed in 501c3 and their supporting regulations. A supporting regulation under the Internal Revenue Code is 1.501c3-1, which lays out in more details these tests that are described on the screen and enumerates in more subtle detail some of the allowable charitable purposes if you're interested in reading through that, elaborating over those primary purposes that I just described. So in order to be exempt as an organization under Section 501c3, the organization must be organized and operated exclusively for one or more of its charitable purposes. And if an organization fails to meet either the organizational test or the operational test, it is not considered to be exempt or could be at peril of losing its tax exempt status. So generally, the organization must be organized and operated exclusively for an exempt purpose. Exclusively, however, has been interpreted as primarily through some internal revenue rulings. And basically that means that the organization cannot engage in more than an insubstantial amount of non-charitable activity. Very important in keeping tax exempt purpose. When an entity forms and files with the IRS, it's Form 1023. It's describing to the IRS its organizational documents, and there they will be looking at the organizational test. What is the organizational test? The formation documents must set out its charitable purpose. And in looking at the bylaws of the organization, which is the internal governing document, describing how the board will interact and will work, but certainly a portion of the internal bylaws, which are private to the organization, will describe how you're fulfilling your mission and your charitable purpose in conjunction with your articles of incorporation, which is the more publicly filed document, typically with the Secretary of State in whatever state you're forming in. Those documents should accomplish a few things. They should certainly limit your purpose to one or more charitable purposes. They cannot expressly empower the organization to engage in non-charitable activities, as you could therefore stand to lose your tax exempt status or not gain tax exempt status, other than the insubstantial amount of non-charitable activity that I just described. And assets must be dedicated in perpetuity to the organization's charitable purposes. So a really important clause that all 501c3 tax exempt organizations have to have is a dissolution clause that states, should the entity dissolve, its assets must be distributed to another 501c3 entity in furtherance of its exempt purpose. Those types of things are the organizational test, again, which will be set forth in your corporate governance documents, and perhaps also enumerated in supplementary policies that your organization may put into place. So that's one prong that the IRS will be looking at, your organizational test. What's the operational test? The operational test is how you're implementing what your organizational test implies, right? You must engage primarily in activities that accomplish one or more of your exempt purposes. And again, you will not meet this test if more than an insubstantial part of its activities is not in furtherance of an exempt purpose. And I will say there is no real bright line rule about this insubstantial test, unfortunately, to give us some bright line guidance, and has been interpreted in private letter rulings. But what the IRS will be looking at is basically how you operate in fact. So for example, that you're not engaging in excessive lobbying activities, that you're not engaging in prohibited political activity. And a big portion of this regulation, should you look at it, interprets scenarios where you may be benefiting in a substantial way private individuals, known as excess private inurement or excess private benefit. So that's certainly something that you have to keep in mind. Generally, the notion in the regulation is that earnings cannot be distributed to private individuals or groups of individuals not in furtherance of your charitable purpose. So at all times, 501c3 entities certainly should be maintaining checks and balances in place and not engaging in mission drift, which will allow them to violate the organizational test or the operational test. And I'll pause there to see if you have any questions.
Yeah, we have one come through, and I'll let you respond to this one. And actually just a quick note to maybe speak a little slower for our captioner.
Sure.
So we have one comment that some basics would be helpful. If you were trying to join a fiscal sponsor, do you also need to be a 501c3 nonprofit first?
So we'll go over the different types of sponsorship models, but generally, no, you do not. You do not, depending on the model. You do not have to be a nonprofit first, no.
and I'm thinking you're going to answer this one as well soon, but to finish off this person's questions, the program I direct is part of a 501c3, but if we leave to go to a fiscal sponsor, so do we need to file or become an independent nonprofit as a prerequisite?
So again, I think that's a similar type of question. No, you don't have to. If I'm understanding, you're leaving the existing project and perhaps going off on your own and starting your own project, maybe similarly aligned, but it is not a requirement for you. Did you say a fiscal sponsor or project?
They are a 501c3 and considering switching to a fiscal sponsor.
Okay, yeah. So again, you don't, if you're a project who is looking to engage with a fiscal sponsor, there is not a requirement. I mean, again, depending on the fiscal sponsor's requirements, I suppose, but and what type of program they engage with. But generally, you do not have to be a formalized nonprofit entity with tax exempt status or even a corporation under some of the sponsorship models to engage as a project with a fiscal sponsor.
Right. So as attorneys, what I would advise is if you're currently a program of 501c3 and you're looking to spin out outside of the 501c3 and get your own fiscal sponsor, and we'll talk about the pros and cons of doing that in future slides, but I would always recommend that you form an entity, a legal entity. If you don't have a legal entity, then the people who are putting on these programs, if you're not officially part of another legal entity, you're really putting yourself at some substantial risk. Legal wise, tax wise, you might have to report income on your individual tax returns. If something happens, you can be personally liable. So generally, we advise people to form some sort of organization if they're running a program, especially an ongoing program outside of an existing organization.
And I think you'll see it as we go into some of the other slides with the types of fiscal sponsorships and what might be right for you, whether it's a hard and fast requirement. But typically for the B and C, certainly type of sponsorships, yes. Okay.
Okay, so what is a fiscal sponsor? So we are going to use the definition from a magazine called Nonprofit Quarterly, because I think it summarizes the definition fairly well, that the term fiscal sponsorship broadly refers to a number of contractual relationships that allow a person, group, or business to advance charitable or other exempt activities with the benefit of a tax-exempt status of a sponsor organization. Now, there are a couple of key words in this definition. The first one is contractual relationships. This is where a lot of people do it incorrectly. As lawyers, we're going to tell you to get a contract between the organizations. If you're looking for a fiscal sponsor, someone to help you out, you should be having a contract with that organization to spell out everything, to spell out who owns the project, how money's going to work, who's going to supervise it, and all of that. So there should be some sort of contractual relationship between the two entities or the two organizations. The next word is advanced charitable, or the next phrase is advanced charitable or other exempt activities. So this is where Liz's last slide comes into play. The activities still have to be charitable in nature in order to get a 501c3 company to fiscal sponsor your project, your organization. If it's not charitable in nature, it could present some risks for the fiscal sponsor that we'll go through in a subsequent slide. So basically, and then the third part is the tax exempt status of the sponsor organization. This is generally what draws people into a fiscal sponsorship arrangement. They say, we have this project, we have this program, we have this organization. We want to have people donate to us and be able to take tax deductible donations from those donations, to take them as a tax deduction. So you're looking for a sponsor that is a 501c3 entity to allow people to donate money to that entity in order to get the tax deductions. So what a fiscal sponsorship is, it's a way to team up with some 501c3 organization to provide financial, which we just spoke about, or administrative support for a project or organization. You may not need the tax deductible donations. Instead, you may be looking for a fiscal sponsor for administrative issues to help you through stuff, maybe even to put people on payroll so you don't have to attend to all the administrative matters that are included with running a company. It's not a fiscal agent. So it's not the same as a fiscal agent. A fiscal agent is generally an entity that's just going to hold the funds for another organization. Fiscal sponsorship goes beyond the fiscal agency. Fiscal sponsorship includes the concept of oversight, management, and some other concepts depending on the type of fiscal sponsorship that you go into with an organization. And what it is definitely not, it's not borrowing someone else's 501c3 status. I've heard it numerous times that people let projects piggyback onto their 501c3 status. They tag team, they just, a friend has a charity and they want to do some projects, so we're just going to funnel the money through this charity in order to get tax deductions. That is not recommended, and it can create, again, it can create a lot of issues, and we'll go through the issues that it will create on one of the subsequent slides.
So what are some potential reasons to enter into a fiscal sponsorship? Russell just mentioned an important one. And really this slide is more maybe from the perspective of the sponsoree. So certainly a big one arises under the second bullet there, urgency, where you can't wait to receive an IRS 501c3 determination letter. If you have gone so far, maybe as a filing. Right now, those determination letters from the time of filing, in my experience, are taking anywhere from 3 months to up to a year, and remains to be seen with some of the staffing cuts, how that will be impacted. So you might have a donor waiting in the wings for your project who's excited about it and wants to get the tax deductibility with a 501c3 entity. So that might make sense for you, certainly, to identify a fiscal sponsor. And certainly, perhaps in the case of the third bullet, where you don't want to go so far as to create an actual legal entity, and as Russell mentioned, there might be good reason to do so, but particularly for the fiscal type A type sponsorships, which I'll go over, might not be necessary. It might be an opportunity then to locate a fiscal sponsor to try your project. The point of testing the waters or the permanency of the project or need. Some of these projects may arise in the wake of a perhaps natural disaster, a public health crisis that hopefully is just intermittent. And, that might be a good reason if something's temporary and there's not longevity to the project, to find a fiscal sponsor who's aligned with the purpose to implement a project for a short period of time. Perhaps certain persons have the necessary expertise to implement that project, and it might make sense for you to join together to accomplish that charitable need. Again, whether it's a period of years, but not necessarily a project that might exist in perpetuity. For some of those projects and organizations that are in their infancy, whether they formed a legal entity or not, they might need some education. They might need to get up to speed, and perhaps working with the fiscal sponsor, they can supplement them with administrative knowledge, administrative assistance, volunteers, provide them with policies to put into place to assist with the administration of the project. And it certainly allows the persons implementing the project then to spend more time focusing on the actual charitable mission, rather than all of the administrative concerns that certainly come to rise with forming their separate 501c3 nonprofit organization. So that may assist. I'll pause there to see if we have any questions from the last two slides.
No, not pertinent to these.
Okay.
Okay, so now we'll get into how it works. So your organization is going to look for a 501c3 whose charitable mission aligns with your project. So if you're a farming type of project or an agricultural project, you're not going to look to the American Red Cross or some other type of focused charity for fiscal sponsorship. You want to look for either a entity that works in your area, meaning whatever your project you're trying to do, find an existing charity to try to team up with. Or there are some organizations whose charitable mission is to just be a fiscal sponsor. One of the main ones in the area is an organization called TSNE, which is Third Sector New England. They may have changed their name to TSNE, but it used to be called Third Sector New England. And the business model is basically to fiscally sponsor other charities. They may have specific programs that they're looking at, but they are a 501c3 whose purpose is to help other organizations in their charitable, put on their charitable program and work to gather the tax deductible donations, oversee the programs, and help you run your whatever project you're trying to do. There's three main types of fiscal sponsorships. I don't know if people can see me, but it's all coming from, there's one book that talks about fiscal sponsorships. It's basically the Bible from an attorney out on the West Coast, Gregory Colvin. It's called Fiscal Sponsorship, 6 Ways to Do It Right. We're only going to talk about 3 ways. I'll mention the other ways, but they're not really the type of fiscal sponsorships that we're talking about. First way is a direct project, which is called Model A, and Liz will talk about that on the next slide. Second way is an independent contractor project model, which I'll talk about, a Model B. And a third way is the grant relationship method, Model C. The fourth way is what's called a supporting organization. These are actually 501c3 entities that are linked up with other charities. So a supporting organization, think of a university that has an endowment as a separate 501c3 organization. Or in Boston, there's the hospitals, and then the parking lots are owned by other 501c organizations. Those organizations support the hospital, and they get their nonprofit status solely because their function is to support another nonprofit. Now, those are a type of fiscal sponsorships, but they're generally referred to as supporting organizations. The fifth type that he talks about is called group exemptions. The most common one is the Catholic Church, where you have one organization that's a 501c3, and all the affiliates are under the group exemption. So they are all considered nonprofit charities because their parent organization, for lack of better words, is the nonprofit itself that's recognized by the IRS. And the parent sends a list each year or updates the list whenever they have new subsidiaries or new entities coming in and out of the organization. And then the last type of fiscal sponsorship is just administrative assistance, teaming up with a 501c3 to provide administrative assistance such as bookkeeping, personnel, etc. But the ones that we think most people are interested in are the actual Model A, B, and C, where you're getting some sort of contractual arrangement with a 501c3 to do a specific project or run a specific program. Liz, do you want to take us into the Model A?
Sure. So I'll start with the Model A, known as the direct project fiscal sponsorship. So again, the first step, if you're the sponsoree or the project, you would be looking for a 501c3 entity whose charitable mission aligns with your project. And as Russell mentioned, this may often be a type of nonprofit entity that may act as an incubator typically for nonprofits, or as part of its mission, is looking to grow the nonprofit sector and has an umbrella of nonprofit entities or projects that it works with just regularly as part of its charitable purpose. This type of Model A direct project, when the sponsoree approaches them, typically does not have any separate legal existence, certainly at the time of inception. So therefore, the sponsor, the board should certainly be aware and approve through its corporate governance mechanisms, or have some kind of policy in place of vetting of taking on these projects, certainly to ensure that it aligns with its charitable mission. But also because there is no separate legal entity in place for the sponsoree or project, there will be perhaps an employer-employee type of relationship with persons involved with the project who are working on it, or a volunteer type relationship. So if there is, for example, an employer-employee type of relationship, the board should be aware and properly withholding, for example, payroll taxes, workers' comp taxes, unemployment taxes for the employees then working on the project. The sponsor in this case typically would own all the assets of the project, and hopefully would be implementing a separate bank account, for example, for any contributions made to the project. And it typically would be categorized as a restricted fund on the Form 990 for the sponsor. And perhaps the sponsor may be taking a percentage of that restricted fund as its fee for implementing the project. This project certainly at inception will have the least amount of financial independence for the project. And on the sponsor's side, because there is no separate legal entity, it is just coming under the umbrella of the sponsor's charitable organization. They also would be held liable for anything going on with the project, right? So certainly something to be aware of. If there was acts or omissions by the employees, if there were accidents on the property, obviously in the farming and farmers market space, there's a lot of regulations pertaining to food and safety storage. There might be vendors. So just keep that in mind from the sponsor's point of view. From a liability point of view, this would be the most tied in to the sponsor's organization. Transfer of the project, very important, because we do have a slide at the end about potential hiccups with these arrangements, but how a transfer of this type of project might arise and be implemented. The sponsor should certainly, again, have a method to identify any tangible assets associated with the project. Tangible assets meaning stuff or equipment or ownership of assets associated with the projects. And certainly would have hopefully that restricted fund in place that they've been accounting for separately, all of the charitable contributions related to the project, and also would be able to identify any liabilities potentially associated with the project as well. There should be an agreement in place, for all of these types of models. We'll talk about best practices and certainly agreements that you want to have in place between the sponsoree and the sponsor. But the agreement should contemplate, for the direct project model, preconditions of release by the sponsor. So, what will the sponsor need to evaluate to feel comfortable if at some point, maybe this would never happen, perhaps, but what is the transfer method, and what does the sponsor need to evaluate to feel comfortable to agree to let this project go and flourish on its own? So is it perhaps that the organization has formed its own entity or is going to do so, or has filed for tax exempt status? Is it that they will need to demonstrate that they have another fiscal sponsor? And certainly who within the organization of the sponsor would have the authority to release that project? Those are just the types of things that should be put into place with an agreement contemplating the transfer of the project. Not sure if you have anything to add, Russell. I'll pause there on the type A. Model A. Type A, that's me, but Model A.
Yeah.
We're all type
nothing,
A, right?
nothing to add on that. Yeah.
Okay. All right, let's scoot over to Model B.
Yeah, so I'll take Model B. I don't know what a type B person is. Maybe I'll take that as well. This one is the least common method and the one that poses the most risk to a 501c3 organization. It's an independent contractor arrangement. Sponsorees generally view this as what they're looking for, but in this model, it's sort of the opposite. In this model, it's the charity that is generally going out to find an independent contractor to do some sort of program that it just doesn't have the capability or personnel to do. So the program would belong to the sponsor, but they're looking to contract out the operations to a third party. The charitable donations still go through the 501c3 sponsor, and the sponsor will try to make some profit out of the arrangement by charging an administrative fee. The types of projects that sometimes go through this model is if you have a big charity that say they want to do some sort of film or they want to write a book. They'll find an independent contractor to actually do it for them, but the money will go through the nonprofit. The nonprofit will pay the contractor, and it's sort of hands off for the nonprofit, which is why it poses the risk to the nonprofit organization. And whenever a nonprofit is giving money to outside agencies or organizations, there's always a risk to the nonprofit that if something is not being done correctly, it can affect its nonprofit status. So we don't really see this model that much. We generally see either Model A or Model C. Liz, do you want to take us into Model C?
Yeah. Do we have any questions, Mary, or should we good? Okay. So let's go into Model C. So as Russell said, Model C, definitely one of the most popular models. I think sometimes though not implemented in the correct way. So let's look at Model C. Model C is akin to a grantor-grantee type of relationship. So if we look at the spectrum of Model A, where I mentioned oftentimes the sponsoree, when engaging in a Model A type of relationship, might not have a legal entity in place. With Model C, the project typically is it's independent. So, and oftentimes it may have its own legal entity, have its own tax identification number. It may be formed as a nonprofit entity, a business association, or certainly sometimes with individuals, just attributed to an individual. And obviously you would have to weigh the pros and cons of formation and what type of tax exempt entity, which we went over at the beginning, might be appropriate from the project side. But just high level, typically when you're engaging in this type of relationship, you would have your own tax identification number, your own legal entity in place when you're engaging in the Model C grant relationship. So in this case, again, looking at the spectrum from Model A, where the sponsor really does have much control over the project, in the Model C relationship, as the second bullet indicates, it says the sponsor doesn't own or control the project. And that's with a somewhat of a caveat, right? The sponsor does maintain some discretion and control with regard to the implementation of the grant, as it should for any grantor-grantee type of relationship. And the book that Russell mentioned drew a line of similarity, which I think maybe some of you in the nonprofit space can think of synonymously, is with, for example, donor advised funds, right? Many people have donor advised funds in place with a charity. Certainly the agent or the person contributing the money to perhaps say the community foundation where the donor advised fund is set up makes requests as to how they want their money distributed, but ultimately the charity that is implementing the donor advised fund has discretion and control, or the final, let's say, blessing as to if that suits them to distribute the monies. So let's look at how practically this might be implemented. The sponsor should have, as it would for any type of grantor-grantee relationship, should have grant-making policies in place to guide them through this. The organization or sponsor would submit a grant request to the sponsoree, would submit a grant request to the sponsor. The sponsor would then evaluate if that grant request was in furtherance of its charitable purpose, which is certainly a theme throughout all of these models. And certainly in as part of that should be reviewing things like potential fundraising materials that would be put out there to the community, just to make sure there's no risk to the sponsor organization. The board would have as part of its grant approval process. That's memorialized in their policies, an approval process as to what they would be looking at in terms of what's appropriate for the sponsoree or the project. And if they say, yes, we will make a grant to support this project, they would then execute a grant agreement, which they would have vetted, in place, a grant agreement that would protect the sponsor and the sponsoree. The sponsor's bylaws would provide typically that solicitations or conditions that the sponsor has some discretion over the funds, right? So for example, they would be engaging in expenditure responsibility, which is really, a phrase that's pertinent to private foundations, but all grant makers should, as a best practice, engage in some type of expenditure responsibility. What does that typically mean? That the way that the grantee is representing, they're going to implement the funds. They are in fact implementing the funds in that way. So the sponsor organization should be certainly working with the project to make sure they are utilizing the funds in the way that is described in the grant agreement, whether that's periodic reporting on a certain annualized basis. And the sponsor would be able certainly to have some right, if the project has gone off the rails or through the reporting, they're seeing that it's not being implemented in the correct way, to hold back further funds or even try to claw back those funds that have been distributed to the project. So there is the expenditure responsibility piece, which is mentioned on the slide here. The sponsored organization, or the sponsoree, as we're calling it, may certainly or will recognize taxable income with regard to the grants that they're receiving from the sponsored organization. So that certainly is what's relevant with regard to the tax status or the legal status of the sponsoree when they're engaging in this type of relationship.
Right. And on that last bullet, it's generally a surprise to the sponsorees because they think they're getting tax exempt grants. Most grants are not tax exempt. You might get some grants from the federal government or the state government that under specific laws might be tax exempt. But if you're getting money, it's generally for tax purposes classified as income. And if you're an organization, well, if you don't have an organization, then the people running it could be subject to taxes, whoever determines that, whoever owns the project. If you have an organization, you can have an organization that incorporates in Massachusetts under Chapter 180, which is the chapter for charitable organizations. Doing so does not mean you're tax exempt. It's just the first step. Without actually applying to the IRS and getting a letter back from the IRS saying you're tax exempt, you're still a taxable entity. So just the fact that you've set something up under Massachusetts or another state under its charitable corporate statute does not give you tax exempt status. That's the next step you have to go through. So, and without that status, when you receive grants, it's generally going to be income.
Very good point. And I would say from the sponsor's point of view, we talked about for the Model A, how there was a lot of liability risk for that type of model because everything is under their umbrella. There's no separate legal entity involved for the project. This model, from the sponsor's point of view, would have the most limitation of liability because, again, it is there's always some liability in place which would be addressed through the grant agreement, but because they are simply passing through grants in according with their grant making policies, I would say this provides limited liability, more limited liability to the sponsor. Okay. Next slide.
So the elements of a fiscal sponsor, as we've been talking on basically each slide, this is a contractual relationship. For each of the models, there should be a contract. I'm going to skip down to the third bullet here, describes the project ownership. Many people enter into these types of arrangements, and then a year or two it's successful, and then they say, well, we want to spin out and go out on our own. Well, there could be some issues there. Generally, people may not realize that they don't own the project. even if the nonprofit has been hands-off, legally, under their contract, it's probably owned by the nonprofit in order to protect the nonprofit's nonprofit status. They have to basically own their assets and own whatever they're obtaining from distributing money to these projects. So generally what we like to see in the contractual relationship is the last bullet, some sort of out clause that if the project managers at some point in time want to go out on their own, that there's conditions that the 501c3 will allow them to do so. And generally that involves getting recognized from the IRS as a 501c3 entity. So in the arrangements I've seen, the fiscal sponsor is hesitant from letting you take on the project unless it's going into another 501c3 entity. The other aspects of the contract, it outlines all sorts of responsibilities, what the projects can do, what the project can't do. Specifically, a lot of these arrangements say the project can't do anything with politics or electioneering, because that can hurt the 501c3, that can hurt their charitable status. How much time is supposed to be involved in the project and what fees. So the fiscal sponsorship generally is not doing this solely out of their good nature or charitable purpose. It costs them money to enter into these arrangements. Just think accounting fees, legal fees. So they're going to want to get some sort of services fees back. Generally, it's a percentage of the money that goes through the fiscal sponsor. So whatever money the project raised, the fiscal sponsor gets a percentage of it. So we do look for all these issues in a contract. There are many people that do informal fiscal sponsorships without contracts, and it costs more to unwind those than it would have cost to hire appropriate legal help to get them done correctly in the first place. So you want some sort of contractual arrangement upfront that everyone agrees to, so that there's going to be no surprises if and when you decide to move out of the fiscal sponsorship arrangement.
And I think that contract that Russell just mentioned will certainly avoid, hopefully, many of these pitfalls. And we have mentioned many of these as we've gone through, I think, each model and the description of what should be included in a contract. But this is just a good reminder for both the sponsor and the sponsoree. Let's just start at the bottom. I think policies are certainly very important and often overlooked. And sometimes the worst thing that can happen is either a sponsor can have a policy in place about how to vet projects and not be following the policy. So policies are only so good as to the extent you follow them. But some of the things you might, as a sponsor, want to include in a policy for fiscal sponsorship, basic things like requirements of who can apply, policies that govern the expectations of the project. As I mentioned earlier, making sure you're reviewing before you engage in a relationship all of the ancillary and fundraising materials pertinent to the project, who has signatory authority, whether that be for the sponsor, but also perhaps can be relevant for the project or the sponsoree, and who is responsible for reporting and how frequently you want reporting for that expenditure responsibility piece, or just to maintain the nature of the relationship in the project. Another thing that can come into place is appropriate use of name for the sponsor on materials. So just thinking through maybe some of that IP related or licensing related issues that might just practically come into place, and making sure everyone's properly using the sponsor's name and getting consent for that. We've talked about a couple of other things that I'm not sure we mentioned a lot is IP. We've talked about transfer of assets, but sometimes that can arise to some extent with some of these projects that are going on. And so the agreements you put into place should, mention who owns any intellectual property and how that would be transferred. in the event of a separation or ending of the relationship. Another thing just to be leery of is unfortunately, just to be mindful of in bankruptcy or that type of context. Certainly for maybe some of these Model A projects, just be mindful, and that has arisen in a couple of situations. If there is a bankruptcy of the sponsored charity, what are the implications to you as the project? And I'm certainly not a bankruptcy attorney, but there might be varied results there depending on the nature of the fiscal sponsorship. So make sure you're just aware of that, and obviously the fiscal vitality of the sponsor as the project that you're entering into this relationship with, if there's any risk there. So making sure you're certainly evaluating their Form 990, having an understanding about their financial and fiscal health to protect the assets of your project. As is also mentioned on the slide, the scope of liability changes, certainly for the sponsor, depending on the structure of the project. For every project, you just want to be mindful that the sponsor is not at risk of losing its 501c3 tax exempt status for mission drift purposes, for failing that organizational and operational test, or for the project engaging in violation of the lobbying rules or the political activity rules, and reputational harm on both sides of the project, right? You don't want to be affiliated with a sponsor who's engaging in bad acts in the community, and vice versa for the project. So making sure you do due diligence on both sides before you enter into this project to make sure you feel confident in the nature of your relationship. So, both sides can thrive as you continue to grow your charitable mission and purpose.
On the intellectual property, the IP issues, one thing that charities should keep in mind is that their name is one of their most important IP, one of their most important assets. So lending your name to a project, it's recommended that the charity really does its due diligence on the project to make sure that it fits within their charitable purpose, as well as the people who are running the project fit within how the charity wants to be perceived publicly, because some of the fiscal sponsorships are really an arm of the charity and can be perceived by the public as being part of the same charity, particularly if the charity's name is involved.
Great. Thank you. Thank you. I'm just kind of flagging the time. How do you feel about moving to questions, Russ?
I think that was our last slide, right?
Yeah, that was it.
So good timing.
Perfect. Yeah, we've got a couple. For anybody who has to go, we will hopefully be putting this on our website. I'll send a follow-up email. So a couple questions. One was, if a group has been fiscally sponsored by an organization, how can the group access liability protection?
So it comes down to, well, the questions we would ask is, how is it fiscally sponsored? If the group is an actual organization, meaning it's a legal entity, they should be able to get their own liability protection. If it's not a legal entity, you would want to have as part of the contract to make sure that the 501c3's insurance would cover this organization's activities. And many charitable organizations have insurance that covers outside programs, so outside activities, outside events. So that is part of that's a great question. It should be part of the contract and something that you speak about to the nonprofit upfront, that you're doing these activities. You want to make sure that you're covered under some sort of insurance policy.
Yeah. So to kind of state in plain language, and this is a little bit of a question, it is possible that a group can be an LLC and still get fiscal sponsorship and almost advise.
Yes.
Right?
Yep.
Yes. Yeah.
Right. Great.
Yeah,
And
and in that
could,
case, they would want to look at, certainly their own, as Russell mentioned, insurance protections. And obviously an LLC provides them with liability protections, which we could do another entire presentation on, but
Right.
so.
Great.
yeah, and the group could also be a corporation organized under Chapter 180.
Okay.
And non-501c3s may have less concern with giving fiscal sponsorships to a corporation than to an LLC, just because of the way LLCs work and the ability for the owners of the LLC to take some of the profits.
Okay. The next question, do you have an opinion on reasonable fiscal sponsorship fees?
Yeah. That was actually mentioned, I believe, in the Bible that Russell mentioned. And I believe it said the scale was 5 to 15%.
Yeah, that's my recollection as a common rule of
Yeah.
thumb. It depends on what services are part of the fiscal sponsor. For instance, if you use a fiscal sponsor as what's called, if you use them for the hiring of the personnel, sometimes called a professional employment organization. So if the sponsoree has employees, but you want to have them employees as of the 501c3 organization instead, the fees are going to be higher to cover those costs. But 5 to 15% is a reasonable rule of thumb to go by.
Okay. And one more, we've actually got a couple more questions. So, Liz and Russ, let me know. Do you need to?
Yeah, sure, absolutely.
Yep, well,
Okay.
we're fine.
Well, one request is whether you can follow up with some templates, for fiscal sponsorship agreements, or maybe a resource. So I'll email you for that.
Yeah,
I would just refer, I'm not sure we can send templates, but I will, I mean, we're really plugging this book, but I will say in this book, which, I'm sure you could send out the information about that. There is some good template language, suggested template language in the book. So I would certainly consult that as a good resource.
Okay, great.
you can do a general Google search, and some of the names are reputable. Like I just did one in Stanford University has some, which they have these big disclosures on saying, we're not updating this, but here's a template to see what it looks like. So just take what you see on the internet with a grain of salt. If it's from a governmental agency or a reputable nonprofit, you can maybe use that as a template. But if it's on a site that says fiscalagreementsrus.com, maybe not use that type of a site.
I mean, we do recommend you always consult with legal counsel.
Yeah. And both parties should have legal counsel because they have divergent interests. So as that's actually a good point. As a sponsoree, the non-profit will probably do the draft of the contract. Do not rely on the nonprofit's attorneys for advice. They're actually adverse to you in legal language. So you would want to get your own counsel to negotiate these types of contracts.
Yeah. All right, we've got 2 more questions, so then we'll cap it at those 2. For Model C, if the fiscal sponsorship agreement specifies the uses for which the sponsoree can use funds, does the sponsor need to approve all grants in advance, or can it just follow up with reporting at the end of the year to ensure that they are used in accordance with the contract?
Yeah, I mean, I would think if I was representing the sponsor, I would suggest they have a mechanism in place to, at least review and pre-approve each grant. Because again, I think the liability would be on them, for issues surrounding the mission drifts that I mentioned, or protections for the sponsor. I guess, I could certainly foresee if they were implementing many small grants and that just wasn't feasible or something like that, where that could be described in a contract to make a sponsor feel comfortable. And then I would certainly ensure that for each grant within I don't even know if I would wait a year in that case, maybe 6 months or something, they would have some kind of reporting obligation to the sponsor. So I would say best practice, I would recommend the sponsor is reviewing and has an understanding of each grant, prior to, but if there's many small grants being implemented and it's just not possible and the sponsor feels comfortable with that, just making sure that there's responsibility and reporting, maybe on a more diligent or rigorous timeframe.
Great, thank you. And last question, again, about the Model C relationship. If the sponsored group does not have 501c3 status, will they always end up paying income tax on the grants they receive through the sponsor in a Model C?
Yes, they would, if they are not a tax exempt entity. If it's just an individual or, you know, a business entity, you know, they would be paying income tax in accordance, with whatever their entity status is, yes.
Right, and just to be clear, it's not just 501c3. So there are 29 plus categories from the IRS to tax exemption. If the sponsoree, in general, I'll say this, if the sponsoree has any of those classifications, then they may not have to pay income taxes. Their accountants, their counsel should be able to walk them through that. But if they don't have anything from the IRS, and particularly if they're either a corporation or an LLC, most of the time, these grants that it's receiving are going to be taxable income. So one thing to realize when you're budgeting as a sponsoree, that you may have to pay 20%, 30% of the amounts that you're getting in as a grant in taxes.
Great. Well, thank you both so much. That was really wonderful. Before people go, if they have the chance to click on the link in the chat to provide webinar feedback, we would much appreciate it. And then you're also welcome to join us for our next week's webinar, which is on succession planning. And then after that, there's one on nonprofit formation. So anybody here who might be interested in nonprofit formation, we have another webinar coming up. So thank you so much, Russell and Elizabeth, and everyone else.
Thanks for having us.
Have a great rest of the week.